Tonight, a nationwide discussion about police power to seize private property.
Civil asset forfeiture is a hot topic at the Capitol. A few weeks ago, we told you about it, and it happens when you're accused or are guilty of committing a crime.
If you are accused of committing a crime with a gun, for example, that firearm is seized and taken into evidence. But depending on the crime, some property is never returned to the owner. It's forfeited due to its involvement in criminal activity.
Renee Cooper tells us why the U.S. Supreme Court is taking part in deciding what law enforcement can forfeit and how it affects our state.
A couple weeks ago, I broke down legislation in the North Dakota House of Representatives that would put limits on civil asset forfeiture and create a record-keeping system for law enforcement. 2 days later, the U.S. Supreme Court ruled that the Constitution already places limits on states' ability to take and keep property involved in crime.
Ultimately, they decided that the Eighth Amendment excessive fines applies to the states, and judges should have the leeway when it comes to asset forfeiture of whether or not the asset was excessively forfeited.
As Bismarck Police Sergeant Mike Balmy explains, the Supreme Court ruling is all about proportionality, meaning the money or property forfeited shouldn't be worth more than the maximum penalty for that crime.
So say like a Class A felony, I think is $20,000 maximum fine. Proportionality would mean that that person, you couldn't forfeit more than $20,000 of that person's property.
But law enforcement does have some leeway. For example, if a drug case results in that $20,000 maximum penalty, but the suspect used a $40,000 car to sell those illicit drugs out of, police can argue for forfeiting that vehicle.
We want to be fair to, obviously, to all of our citizens, and at the same time, we don't want to reward drug dealers by giving them drug money back.
The State's Attorneys Association director has been following the nationwide discussion and says North Dakota hasn't seen the excessive forfeiture that he's noticed across the country.
So we've kind of self-policed ourselves, but the reality is this just now tells us what you were doing in North Dakota is the right move.
If you're following the rules like we are, then it's not going to change anything. We do our due diligence for asset forfeiture. It's just like case building for trying to prove somebody guilty or innocent. When we work these, or when we do these asset forfeiture proceedings, we make sure the evidence is there. If it's not there, we give the property back.
In the Indiana case that sparked the Supreme Court ruling, whether or not that property will be returned is still up to an Indiana state judge. What's new is that after criminal proceedings are said and done, you can argue that it was excessive under your Eighth Amendment rights. Reporting from the Capitol, Renee Cooper, KX News.
Ultimately, Representatives Satrom and Burse say the ruling will have little effect on the legislation now in the Senate, other than reiterating that police should not seize excessively. For more on House Bill 1286,